Anchor Michael Williams serving as our moderator. Michael has 33 years of experience in television, and at this point, I'm going to turn the program over to him. Michael.
Thank you very much, and good afternoon. The death of Trayvon Martin and the acquittal of George Zimmerman. That story, that case, that outcry has largely defined our debate and our views on Florida's Stand Your Ground law. We will certainly talk about that today, but we also hope we will talk about much more in terms of what the law is, what it was intended to do, and whether it needs revision. A bit of history. Up until 2005, Florida law generally held, simply speaking, that you could not use deadly force if it was reasonably possible for you to retreat. Governor Jeb Bush in 2005 signed into law what is now commonly called Florida's Stand Your Ground law. Florida Statute 776.013, Section 3. I will read it in full. A person who is not engaged in an unlawful activity and who is attacked in any other place where he or she has a right to be has no duty to retreat and has the right to stand his or her ground and meet force with force, including deadly force, if he or she reasonably believes it is necessary to do so to prevent death or great bodily harm to himself or herself or another, to prevent the commission of a forcible felony. 21 other states, the number varies depending on how you discuss the application of the law and the sameness of the laws, but generally held that now 21 other states have laws that are similar to Florida's Stand Your Ground law. To discuss Stand Your Ground, our panel includes, and I'll begin at my left and move down the row, Palm Beach County State Attorney David Ehrenberg, elected in November 2012, has said at some point that Stand Your Ground is beyond what the legislature originally intended. He'd like at least a review of it. Mr. Ehrenberg, the state's former anti-drug czar, a former state senator, and former assistant attorney general. Welcome, sir. Martin County Sheriff William Snyder, a supporter of the law which has been unanimously supported by the Florida's Sheriff's Association. Sheriff Snyder, a former state legislator, sworn in as sheriff this past January. Welcome, sir. State Senator Chris Smith, Democrat from Fort Lauderdale, the Democratic Party leader in the Florida Senate. He has called for the law to be revisited or repealed. State Senator David Simmons, Republican from Maitland. While in the House of Representatives, he was an author in 2005 of our Stand Your Ground law, which, as I said earlier, has been used as a model in other states. Senator Simmons first elected to the State House in 2000 and the Senate in 2010. Patrick Franklin next to him, the president and CEO of the Urban League of Palm Beach County. The Urban League is on record as saying it wants the law to be reviewed and revised. State Representative David Kerner, Democrat from Lake Worth, a former police officer who's been appointed to a fall House Review Committee on Stand Your Ground, elected in 2012, and supports seeing the law at least revisited. And Palm Beach County Circuit Court Judge Krista Marx, first elected in 1998 and served on the governor's 2012 Special Task Force, which reviewed the law and, as a group, issued a report essentially supporting the core principles. By the way, the Forum Club would like to make it clear that they extended invitations to both the National Rifle Association and the NAACP. Neither accepted the invitation to be here today. So let us begin. Let us go back to the beginning, 2005. And we'll begin with you, Senator Simmons. Why then, why now did you think Stand Your Ground makes sense?
Well, when Representative Baxley came to me in 2005 when I chaired When Representative Baxley came to me in 2005 when I chaired the Judiciary Committee with the idea that Florida was in the distinct minority of court decisions across the nation. Florida had the rule that a person who is an innocent victim who is attacked has to retreat if they have the ability to do so, and that in fact an innocent victim should have the ability to make in that split-second decision-making, the ability to say they will stand their ground and try to disarm their assailant rather than being forced to flee. Being forced to flee simply puts the life of a criminal much higher than the life of an innocent victim.
Senator, thank you. The Tampa Bay Times did an exhaustive 2012 investigative report. You'll hear me refer to them frequently. Let's look at some numbers. They identified nearly 200 stand-your-ground cases across Florida, including most of the high-profile homicides. They used media reports, court records, and interviewed dozens of prosecutors and other lawyers around the state of Florida. Those who invoked stand your ground to avoid prosecution in this survey, nearly 70% went free. 23% of the cases in the Tampa Bay Times database were dismissed by a judge after an immunity hearing. Senator Smith, you've talked about your concerns about stand your ground, having it revisited or repealed. Those statistics, some would argue, say it's working, say, as the senator said, that it's protecting the innocent. Your view?
Well, that's only a small sampling. The problem with the stand your ground, we don't even know how much and where it's being used. Tampa Bay Times looked at about 200 cases that involve murder, but as we see, stand your ground is being used in school bus fights in Broward County. It's being used in domestic violence cases around the state. We don't even keep statistics on how it's being used and when it's being used. That's one of the major problems when we refer to the Tampa Bay Times. That's only 200 cases. There's many more cases that we couldn't even imagine where the law is being misused and misapplied, and so that's why we should clarify it.
Judge Marx, from where you sit, do you believe that?
I do. I think that there are many portions of the statute that are vague or in conflict or inconsistent, and that it's incumbent upon the legislature to fine-tune it, whether they make a substantive change and whether Florida ever goes back to being a duty to retreat state.
Should it?
I can't opine as a member of the judiciary. It's not up to me to say whether that's appropriate or not. But certainly, the language needs to be tightened up and fine-tuned. The case law would show that the courts, when interpreting the law, are finding that there's vagueness and conflict that needs to be addressed by the legislature.
Mr. Ehrenberg, weigh in on that. Do you see that as the lead prosecutor in Palm Beach County, an inconsistency in the application?
Well, there are flaws in the law that need to be readdressed by the legislature. There are some ambiguities in the law that the courts have exploited to expand the law.
Chief flaw. The chief flaw that you see.
The chief flaw just happened just recently in a case out of Fort Myers. It was the Little case, where they expanded stand your ground to protect people engaged in illegal activity. So now, one appellate court has now ruled that if you are breaking the law, you still can get stand your ground protection, which is mystifying for me and others, because in the very first sentence of the preamble of the law, it says it shall only apply to law-abiding citizens.
We want to talk about that. Let's talk about some of the inconsistencies. And Sheriff, I'd like to put this to you. You have said you, generally speaking, support it. You can use many examples. Here's one. In Winter Springs, a man comes home, finds his daughter's boyfriend angrily stalking up his driveway. He fires a fatal shot. No charges, understand your ground. In Clearwater, another man shot and killed his angry cousin as he stalked up the driveway. That man now in prison for 25 years. Sheriff, you say you've supported the law, but the ambiguity, it must concern you.
Well, Chris, I can't, or Mike, I'm sorry, I can't tell you that I see ambiguity. I think if you read the statute and you read it, it's very clear that the major components require, one, you have to be in an area where you're lawfully entitled to be. Number two, you have to be attacked. Number three, that you're allowed to only use that force which is necessary, or meet force with force, as the statute says. And then if those are met, you have no obligation to retreat. And I'll close that opening remark with this. The onus has to be on somebody in every confrontation. Either the onus is on the law-abiding citizen to explain why they did what they did, or the onus is on the criminal, who I think is where it rightfully belongs. The onus is on the criminal not to attack someone, not on the law-abiding citizen to retreat.
State Representative Kerner, I'd like you to weigh in, and then you, Patrick Franklin, before we talk more about concerns about inconsistencies and a law that at least critics argue has gone outside the bounds originally intended. First you, State Representative Kerner.
Thank you. I think the law was very well intentioned. It passed through the House and the Senate in a very bipartisan fashion, which is unusual in Tallahassee.
Or anywhere.
Or anywhere. It's a product of the electorate. It is the law. but I think that there are very serious issues in the way that it was drafted and the way that it's been applied.
Chief issue that you have, candidly and fundamentally.
State Attorney Dave Ehrenberg touched upon the unlawful activity concern, and that is a big concern. But for me, the biggest flaw in the law has to do with law enforcement's inability to take a suspect into custody after stand your ground defense has been put forth.
Patrick Franklin, President and CEO of the Urban League, your take.
This law has changed our community in a way that it had expanded the retreat policy. And right now we have to talk to our kids on not only do they have to look at each other, but anybody can walk up to any place in time now and say, I felt threatened, so now I can use force against you. And that's not the society we want to live in.
Senator Smith, I see you shaking your head.
Yeah,
in agreement.
Yeah, I think right now, the jury in the Zimmerman case sent a terrible message to Floridians. You have a lot of Floridians now, and you're seeing stand your ground is being used more now. It was passed in 2005, and it was used by some defense attorneys at times. But now that the jury has spoken, many people are now looking to this law and feeling empowered to go out and lead a civilized society. That's not what we are.
Let's speak to some statistics there that I'd like comments from generally across the board. One 2010 Miami area drug deal. One man is threatened with a gun. He then chases down the person in a high-speed chase and kills him. Instead of murder, 3 years in prison for manslaughter. Kendall Coffey, the former U.S. attorney, said the legislators wrote this law envisioning, quote, honest assertions of self-defense, not an immunity being seized mostly by former criminal defendants trying to lie their way out of murder. The Tampa Bay Times database said it found nearly 60%, again a limited survey, 200 cases, but in their 200 found 60% of those who claimed self-defense had been arrested at least once before they killed someone. All told, according to the Tampa Bay Times survey, 119 people in their survey known to have killed someone and invoked stand your ground, and of those people had been arrested 327 times in incidents involving violence, property crimes, drugs, weapons, and probation violations. Sheriff, how does that make us a safer state?
Well, I think if you go to the heart of what you just said, the problem is not with the law. The law is drafted properly, and it's laid out in a very easy to understand pattern. The fact that the judiciary is misapplying or allowing it to be misapplied, excuse me, Judge, or the fact, that defense attorneys are twisting the law to their benefit does not reflect on a flaw in the law.
Judge?
I disagree. I think that when you look at, the courts try to interpret the law as written. There are particular parts of the statute as it pertains to home protection that say the person must be conducting themselves in a lawful manner. Other portions of the section, and Mr. Ehrenberg touched on this, do not say that the person has to be conducting themselves lawfully. Now, we all know that that flies in the face of common sense. Certainly, from the preamble of the statute, it says that this is to protect law-abiding citizens. But when the court is interpreting the law, if the language is missing, we can't write it into the statute. When it was drafted, it was loosely drafted in many issues, imminent, unlawful, many issues within the statute need to be readdressed and tightened up by the legislature.
Why weren't they in 2012? How powerful a voice were you for that in 2012? Essentially, they supported the core principles of it. You were on that group in that review.
I was, and it's often reported that the Stand Your Ground task force recommended absolutely no changes, and I know Senator Simmons would agree with me. That is inaccurate. We identified many of what we believed were the weaknesses in the way the statute was written and requested that those be reviewed by the legislature.
Senator Simmons, do you agree that there are weaknesses among those that have been illustrated in some of the reports I cite, and do you worry that we're a less safe state because of this? Weigh in.
Well, first, everyone needs to know that Florida was a minority jurisdiction in 2005. A majority of the states across the nation, through court-made decisions, had already rejected Florida's really archaic and unreasonable position that a truly innocent person should subjugate his or her life to that of a criminal. And so the United States Supreme Court in 1921 flatly rejected Florida's position that an innocent person had the duty to flee. Let me explain to you that the statute is clear that in order to be able to claim, because you see, stand your ground is only a small subset of the issue of self-defense. It's whether a person has the duty to flee once confronted with deadly force. But in order to stand your ground, you must be the person who had a right to be where you were. In other words, you can't be a trespasser. You have to be the person who was attacked. You had to be the person who was not the aggressor.
But Senator, does that give you a right to then chase them down the street as we see, or in another case, too many?
No, it doesn't, and that's the reason that
and yet some of these people are getting off.
Well, I don't know that, but I know this, that the law is clear. You cannot be the person who provoked the use of force and use stand your ground.
Yeah, right, and the Senate was unanimous. In the bill analysis that was provided to all of us, it said that there's a Florida standard jury instruction in criminal cases that's given to the jury that says that if the defendant was attacked in his or her own home, then that defendant has no duty to retreat. Well, what if you're not attacked? You have a duty to retreat. That's the ambiguity in the old law.
By the way, we do not have a tin ear to the fact that consistently you're hearing people talk about, some people talk about possible changes to the law. We're going to talk about that in the latter part of our discussion, specifically to that as we build to that part of our discussion. But Mr. Franklin, I'd like to say at the very outset I was impressed and taken by something you said, that it's fundamentally changing the community. Given some of the statistics we talked about, is it changing the community because there's more of a sense, to be blunt, that I can go out and get into a confrontation and exercise violence, or is it creating more restraint or more ambiguity in your mind? What's happening on the streets?
Well, from a common man's perspective, from a perspective not from a legal perspective, which this great panel has put together, it has changed the way young people approach their community. They are afraid.
Pardon?
They are absolutely afraid that someone can walk up to them at any point, anywhere, and said, I can stand my ground and protect myself if I feel threatened. Now, from a 17-year-old African-American male who feels threatened by that, we have to take and look at ways of, have we created a safer environment? Is our community safer because of this law? And from our perspective, it's not.
Sheriff, could you please weigh on that? And then Representative Kerner, who had experience as a former police officer, because the fundamental thread we're hearing here is people are concerned that in many ways it may not be making us safer in many respects. Weigh in on that comment, Sheriff.
I completely respect what was just said. I believe that there are communities in Florida and everywhere in the United States where some parts and elements of the community feel less safe than other parts. That does not impugn the validity of the law. It does not change the fact that the law is clearly written, easy to understand, and once you put it into the hands of the judicial system and it gets mucked up, if you use that logic, I would tell you, you better throw up just about every statute, because there's nothing that Tallahassee can write that the rest of the judicial system can't mess up.
We welcome your candor, and one of the reasons we hold the applause for all sides, please, Your Honor, and then Representative Kerner, and then I also see Senator Smith shaking his head, and after this we'll segue into the racial bias of the concerns that we talked about at the outset. But first, please respond, Your Honor.
Well, it sounds like there's a lot of blame shifting going on to the judiciary, but I would say this: when a law is vaguely written, when it is loosely written and has not been applied yet, and you expect the courts, and that means some 599 separate circuit court judges, to all interpret the law the same when it is not precisely written, then you are going to have inconsistency. People, the community, want uniformity in application of the law. They want predictability. But when the legislation is loosely written or vague, you are not going to find that every member of the judiciary will interpret it differently. And I believe if you look at what the task force found after a year, they identified several areas of the law where that vagueness exists.
And you're teeing up a latter part of our conversation, because we will be coming to all of you saying, how do we fix it? But Representative Kerner, you haven't weighed in a few moments. Your take on how it fundamentally in your mind has changed the safety, pro or con, of your constituents.
Well, first let me address the judicial side of it, and I want to echo what Judge Marx mentioned. There is absolutely, without a doubt, ambiguity in the way this bill was drafted and passed into law. The 4th District Court of Appeal has ruled one way. The Second District Court of Appeal has ruled one way, and there is a certified conflict to the Supreme Court. As lawmakers, we have a duty to go to Tallahassee and provide clarity to this law. My concern is that in the political times that we exist, when we have my colleague, the chairman of the Criminal Justice Subcommittee, saying not one damn comma is going to be changed, it's a very difficult environment to operate in.
You're referring to Matt Gaetz, Republican from Fort Walton Beach, who will chair the panel this fall.
And a close friend of mine as well. But it also exemplifies how partisan this issue has really become. And I think this is the value, this room is the value of a democracy, is that we can finally have a conversation about this very important issue.
Senator Smith, weigh in.
Well, I got my committee chair sitting right there in criminal justice, who I'm glad he's here, and maybe this year we'll hear the bill in the Senate. But I agree with with what's being out there. When the verdict came out,
the George Zimmerman verdict.
When the verdict came out, I was on Twitter and I said, even if you think that Mr. Zimmerman's actions were legally justifiable, the legislature has to act to show that it's not encouraged. And so we have to do something to show that the actions of Mr. Zimmerman are not encouraged, and that's not what we envision as a civilized society in Florida. So we have to do some changes.
Excuse me, I apologize, Senator. I want to push back on that, if I may, because the Trayvon Martin death, the death of that teenager from Miami Gardens, and the subsequent trial and acquittal of George Zimmerman, as we said at the outset, has in many ways defined our discussion of Stand Your Ground. As you begin to see, it is both that and is also much more complex. Let me push back with you again on one study from the Tampa Bay Times. They said they found no obvious racial bias in how black and white defendants were treated. Again, a survey of 200 cases only. 73% of those who killed a black person faced no penalty. They did find that 59% who killed a white person faced no penalty. Some disparity there. Democratic Palm Beach County public defender quoted just recently saying, I don't think the law is what we ought to be talking about. I don't think the law is what has caused the injustices that we've been concerned about. What has caused the injustices we've been concerned about are racial inequities, biases, and prejudices. Are we unfairly blaming Stand Your Ground for tragedies? And any death of a teenager is that, but is Stand Your Ground being used as the totem to blame for other deeper issues in society unfairly?
If not prior to the Zimmerman verdict, definitely afterwards. Because as I started off by saying, we've sent a message. We've sent a message, and there are a lot of Zimmermans in this state that now feel that it's right. It's the right thing to do is to patrol my streets with a gun. It's the right thing to do to get out of my car, leave a place of safety, and confront someone. It's the right thing to do because the jury has said it and the legislature has backed it up. That's why I have this man here. That's why I have a sheriff here, a sworn police officer to do those things. But we've sent the message through that verdict. And so going forward, yes, I will blame Stand Your Ground for those subsequent incidents.
Do you believe, though, so that I'm perfectly clear, that Stand Your Ground contains an element, intentionally or unintentionally, that allows for racial bias?
No.
Senator, you've been looking to weigh in for a moment. Senator Simmons.
I can tell you first that Judge Marx was on the Governor's Stand Your Ground task force with me. The first statement that we made in the Stand Your Ground task force was that we reaffirmed that all persons who are conducting themselves in a lawful manner have a fundamental right to stand their ground and defend themselves from attack with proportionate force in every place they have a lawful right to be. Judge Marx voted for that. As far as I know, everybody voted for that. But we also acknowledge that there are some improvements that can be made in the Stand Your Ground law. I myself have already filed a bill to improve upon an excellent law. I don't sit here and say that what I drafted along with my colleagues was in fact a perfect piece of legislation. There are improvements that can be made on it, but I can tell you that anyone who reads and understands the Stand Your Ground law understands the fundamental common sense that it has. And that's what we need to do here, is simply work to improve an excellent piece of legislation. Remember, other states had already adopted Stand Your Ground 100 years before Florida did. 100 years. And they didn't have a lawless society. And this concept that you hear of people talking about that we're going to have a wild, wild west society here in Florida, you're safer today than you were 7 years ago. As a matter of fact, the violent crime rate in the state of Florida has dropped precipitously.
Let me push back on that. First of all, Mr. Franklin, weigh in. Do you feel there's an element of racial bias here, intended or not?
Yes, we're not in a post-racial environment, no matter what, we have a black president or whatever. That does not stand, and our society is reflective of those issues. But the National Urban League just put out a research paper that said that 53% of all the states, the 22 states that have stand your ground, justifiable homicide has gone up 53%.
The mayors against illegal guns.
The mayors against illegal guns. The state of Florida, since 2005, 200% increase in justifiable homicide.
Borrowing their data mostly. I read the same research,
yes.
The Orlando Sentinel article, borrowing mostly from FBI data. And it's worth saying that, again, this is one study, but says that mayors against illegal guns claiming the average annual rate of justifiable homicides in the state of Florida alone up 200% since 2005. By the way, the Tampa Bay Times found, again in its limited survey, it said, could the defendant have retreated to avoid the conflict? Yes, in 135 cases. No, in 36. Unclear, disputed in 66. Senator, you said generally it's a good law, but there seems to be a building volume of evidence that too many cases, there's too much latitude to, as George Kirkham, professor emeritus at Florida State University, put it, I think the law, quote, has an emboldening effect. All of a sudden, you're a tough guy and can be aggressive. Sir? And then Senator Smith, I see you shaking your head.
My statement to you is if you are in a parking lot and you're a woman and a rapist comes up to you and puts a knife to your throat, I can tell you you're not talking and thinking about stand your ground laws.
Nobody's disputing
You're talking
that.
about saving your life, and the split second that you have, do you have the right to go ahead and grab that arm and disarm that individual, or must you be required to subjugate your life to the life of that criminal and run? And the answer is, these things that people talk about, oh, this is a lawless society, it's creating a lawless society. Like I said, we picked this up from states across the nation whose courts had already adopted stand your ground 100 years before. So this idea that somehow or the other this is some new and novel creation is simply incorrect. And I'll tell you also that this whole concept of standing your ground is one that the United States Supreme Court adopted in 1921. So our federal judicial system uses stand your ground. Why? Because properly applied, it is excellent law.
If you got a black man chasing somebody through the street and shoot somebody, I want him in jail just as bad as I want a white man, because I want my kids to be able to walk the streets without people chasing them.
And the answer to that...
So I didn't say it was racial.
And by the way, he's going to join on my bill as a co-sponsor. This language was put in because, and there are two very important lead Democrats who I highly respect. They wanted that language in. I put it in. I realize that it doesn't have definiteness, that we could actually go ahead and put definiteness in it. But the fact of it is that prosecutors have been using it to say, if you have a parking ticket or something very, very minimal, you should not be able, even though you're otherwise innocent and you're attacked, you should not be able to use stand your ground, and you no longer have that option to either protect yourself or flee. So my statement to you is, I am perfectly amenable to putting some, I guess what you'd call meat on the bones for the definition of what is engaged in an unlawful activity.
Mr. Ehrenberg, and then we're going to move to that part of the discussion. I'm only looking this way. We've got a few more minutes before we'll go to some questions, and we'll wrap, and then we're going to go to some questions from the audience. First and briefly, Mr. Ehrenberg, on this.
It's really important what Senator Simmons says, and because the lead House member on this issue has said we're not going to change it, not one comma, as Representative Kerner says. If Senator Simmons can push his bill through and open up the statute again, you can see some improvements. I can tell you in this county we won't have any prosecutorial abuse in these cases.
Well, that's a good jumping off. That's a good jumping off point. I want to go down the line on this because we've bandied about that quote. Will Weatherford, the House Speaker, says the chair will be Representative Matt Gaetz, the Republican from Fort Walton. Why should constituents in Florida think a lot's going to happen when that kind of language is being bandied about? And let's get to the crux of it. Succinctly, what do you think, and I want to go fundamentally should be the chief change or changes to stand your ground, assuming you don't want it outright repealed?
Number one, we need to clarify what is an illegal activity, just as we've been saying. Number two, we need to make clear that people engaged in illegal activity cannot take advantage of stand your ground. Number three, we need to, I think we should make stand your ground be asserted at trial and not pre-trial, not trial immunity by preponderance of the evidence anymore. And number four, right now you could make a motion for stand your ground pre-trial in an unsworn motion. And when that happens, if it's denied, you then go to trial and you can contradict yourself. So, for example, you say, stand your ground applies, I was threatened. And the judge says, no, it doesn't apply. So you then go to trial and your defense is, I didn't do it, my cousin shot him. Well, you just contradicted yourself. And we as prosecutors cannot use that later inconsistency against that defendant because the original motion was unsworn. So those are the changes I would make right away.
Sheriff Snyder.
Well, I would say this. I think that what you're hearing from some of the people up here are flaws in the judicial system. The law is simple. I'm just a poor cop. It looks pretty simple to me. And if I make or don't make an arrest and turn it over to the rest of the system, I have to trust that they'll use their wisdom and make it right. We've heard in every argument, you hear this devolving into we have to send the right message. And I would say this, I think the right message is not that honest people should try to triangulate and figure, do I run or do I stay? I think the message should be to our young people in the community and everybody, don't attack someone, mind your own business, and don't worry about it.
Sheriff, just briefly before we move on, concealed weapon permits, 1.1 million in Florida. We top every state in the nation, and that number is 3 times what it was before Stand Your Ground passed. In the George Zimmerman case, it was argued, the 911 call, the famous one, that essentially police said, let us do our job. Do you worry you're going to have too many people trying to do your job, and do you want it both ways, where on the one hand you say let professional law enforcement do its job, on the other hand, more people who will feel latitude to take it upon themselves, and I'm not talking about the Zimmerman case, I'm talking generally.
Well, I can tell you this, I love Palm Beach County. I'm not sure what they have going on up here, but for my 140,000 residents, we don't have a problem with it. I talked to our lead prosecutor last night, they're not having a problem with it.
Senator Smith, fundamental changes, if you could make your top 3 to stand your ground, or do you want it outright repealed, which given the makeup of the legislature is not going to happen. So what are the fundamental changes you want to see?
Well, to clarify the aggressor stat part of it, as mentioned, it's in there, but still we need to clarify it. One thing in my Senate Bill 122, when I talk about an aggressor, I said someone that leaves a place of safety to confront someone. We must clarify whether an officer can detain. We keep hearing that, oh, it's perfectly written. If you look in section 1, it says an officer cannot arrest, detain in custody, or charge, prosecute a defendant in section 1. Then in section 2 it says, okay, you can arrest with probable cause. You don't have the probable cause in the section 1, so those two are in conflict. So I mean, there's little fundamental things like that you at least need to change so I can allow my police officers, who should be the ones running around with guns and chasing people, to have the ability to at least detain and arrest someone and not have to decide, well, can I not? So we should do that.
I appreciate it. We must move to the question section, and always respectful of your time and your great attentiveness during the day to be here. It means a lot to all of us. Senator Simmons, I'd move to you. Fundamental changes. You said you're willing to look at it. Fundamentally, what are you willing to change?
Not only am I willing to look at it, I filed a bill to go ahead and make and implement the suggested corrections that the governor's task force suggested. As a matter of fact,
chief among them, sir.
Okay, and by the way, the first half of Senator Krista Smith's bill is in fact my bill. So I can tell you that I think we need to deal with Neighborhood Watch and the ability of people in Neighborhood Watch to pursue someone. I think that we have to deal with the immunity provision to make sure that it does not keep law enforcement from doing a full and thorough investigation and then pursuing that. I think that we need to make sure that the civil immunity that exists doesn't apply so that it would protect someone against an injury to a third person who is an innocent bystander. We want to make absolutely sure that these things are clarified. Those are the first top 3 things that I would suggest. I also suggest this, that we expand into other things. We need to probably go back to a 12-member jury so that we can get a better cross-section of our community on our juries rather than having 6. And I can tell you this, my own view of the Zimmerman case, that case was not about the law. It had nothing to do with stand your ground. It was about the lawyers, not the law.
Mr. Franklin, your thoughts?
First of all, we would be in favor to repeal the law entirely, because statistics have shown that the law has caused other problems. But Section 3, the retreat policy phrase in Section 3, that needs to be reviewed. But we also need to bring back the castle doctrine to include the home and maybe the car, not any place that you stand at any given time, and I'm going to stand my ground in that place.
Step Representative Kerner, you're going to get to be with Mr. Gates and talk about where he places the commas. What do you want changed?
Well, let me clarify. I think Chairman Gates doesn't want to change one comma, but I know Chairman Gates very well, and we will get a fair hearing.
And what do you want changed fundamentally?
And I will file a bill with the following changes: to clarify precisely what is unlawful activity, and to empower our law enforcement officers to make the arrest, to investigate the allegations, and to have the judicial process work correctly.
Judge Marx, we'll leave you with the final thought before we go to questions. What would you fundamentally feel from where you sit needs to be looked at, revisited, and revised?
Well, certainly what we've discussed already regarding whether or not you can be engaged in unlawful activity at the time that you try to avail yourself to stand your ground. But also in this statute, it says that along the time continuum of anywhere in the criminal prosecution, arrest, detention, charging, prosecution, immunity can be granted. That has led to great confusion in the law enforcement community. A law enforcement that language is in contradiction of the law, and certainly that needs to be rectified. But first and foremost, it's the illegal activity.
Thank you very much. I'd like to say, for the 7 of you, all learned people, any one of whom could speak at length alone on this topic, to be here today means a lot to our community. And we're going to move to questions, but not without first giving our panelists a round of applause, I think. As is tradition, we have our students here, and we're going to have 2 questions. One from Suncoast High School. If we can have our students stand up. We'll have 1 or 2 of you answer that. We have to be mindful of time. But our students are back there, so we'll have them take the microphone, introduce themselves. First, a student from Suncoast High. Introduce yourself and ask your question, please.
My name is Darlisa Borchin, and I am with Suncoast High School, here with my AP Government classmates. Our question is, has the Stand Your Ground law impacted the number of violent crimes in Florida?
Who wants to tackle that? Go ahead. First, Mr. Kerner got his hand up first, then you, Senator.
First of all, 2002 graduate of Suncoast, and I took AP Government, and I did not pass the test. Now, there's a figure: 200 cases of Stand Your Ground have occurred in the state of Florida. The answer to your question is we don't know, and it's because how many times has law enforcement gone to a scene, Stand Your Ground was asserted, an arrest was never made and never made it to the judicial system? Until we fix that glitch in the law, we're never going to really know what the impact is on violent crime.
Senator, briefly, before we move to our next student.
We know that violent crime in the state of Florida has dropped precipitously. I'm talking significantly over the last 7 years. That happens to be concurrent with Stand Your Ground, but I don't pretend to suggest to you that is causal. I just tell you that we're in a safer society than we were 7 years ago, and that Stand Your Ground as a principle and as a law in most states in this nation has been around for 100 years.
Senator Smith, I'm not sure if your smile was assent or disagreement. Weigh in briefly, please.
Oh, no, I agree. And as I keep saying, I'm looking forward, not in the past before this verdict, but in forward in what we're going to do as a society.
May we also now have another question. This is from a student from the Law Magnet program at Palm Beach Lakes High School.
Hello, my name is Aisha Smith. I go to Palm Beach Lakes High School. I'm here with some of my prestigious Law Academy peers. My question is, was the enactment of the Stand Your Ground law a result of politics?
Because of principle. It's done because people who are in fact innocent victims should not be put into the untoward and unjust position of saying that they must subjugate their lives to that of a criminal.
Thank you very much.
It was voted on, but I can tell you, everyone talks about how bipartisan vote. It was voted on because of politics. because you had a bunch of Democrats and Republicans who wanted to throw a bone to the NRA, who wanted to say, hey, I voted for the NRA on something. They were scared to vote against it. There are a lot of us in the House that said this was bad law. The mayor of Fort Lauderdale, Jack Seiler, wrote a piece on the bill and put it in as an explanation of vote that predicted some of this would happen. So a lot of the stand your ground vote was through politics.
Let me just ask, and then we're going to move to some questions that have been given to me. Many of you in the audience filled out cards. We'll ask a few of those before concluding our program. I've heard this a few times, so I'm only asking for a show of hands. Which of you believe we are a safer state with Stand Your Ground? Which of you think we are a less safe state with Stand Your Ground? Those who think we're safer, bottom line. Those who think we're less safe with Stand Your Ground. And I know the judge and the prosecutor here feel like they can't weigh in. You can't blame a reporter for trying, but nonetheless, let's weigh in with a few final questions. And I certainly respect that, by the way, because the case has come before you. But nonetheless, we wanted to tap into that. And I know, well, let me ask you just from your gut feeling, raise your hands. Which of you think we're a safer state with Stand Your Ground? And which of you feel we're a less safe state with Stand Your Ground? Ladies and gentlemen of the panel, the debate, as you see, even from this small sampling, continues on both sides of this debate. One or two questions for you. Judge Marx, one specifically for you, and you've touched on this perhaps a little. What adjustments should be made to the law to remove, quote, judicial interpretation?
Judicial interpretation is simply this. When a law is written, I mean, there are some judges that are considered activist and some that are considered strict constructionists. We look at simply what the language is. And judges, we wanted, the poll star is what was the legislative intent. But we can't write into the law words that are not there. So it's simply, that is our job, to interpret the law as written. And certainly legislative intent is something that's considered, but we look at the words on the page. So that is what I say, that it needs to be tidied up. It was written years ago. Now that we've seen the case law shake out, there are 5 or 6 areas that have been identified as being weak, and those need to be addressed by the legislature so that there is more uniformity and predictability when the bench is interpreting what those words say and mean.
That may well lead us into our next question. We have time for 2 more, again, mindful of your schedules. This question: so much of the law and discussion revolves around common sense. Common sense means different things to different people. Should such an important law be left to a vague concept like common sense? Senator Smith, you weigh in first, please. And then you, Mr. Franklin.
Yeah, well, I think the obvious answer is no, and that's why Senator Simmons and I are working hard to at least clarify the law. The legislature passed thousands of bills every year, and every so often we have to go back after it's been misapplied or misused and clarify. And I think getting away from common sense, but actually writing the words and what we mean, so the judges don't have to worry about legislative intent, but exactly what we put pen to paper. And that's why Senator Simmons and Senator Evers is going to hear the bill this year, and we'll get those changes done. Right, Senator Evers?
Very briefly.
For several thousand years, we've had self-defense. Everybody understands we have the right to self-defense. It has always been premised upon the idea, were you acting reasonably under the circumstances? Every case is going to depend upon its own unique facts and circumstances. You can't write a law that says too much detail in self-defense. We've always had problems with self-defense and who's the witness and who's still alive and who's not. This is just the way it is when you're talking about that issue.
A final question here that we'll start off with Mr. Franklin, and I think this question may segue to you wrapping up your thoughts. Somebody asked, and I don't believe tongue-in-cheek given what we see going on in legislatures from Tallahassee to Capitol Hill, can the legislature have a, underscored here, reasonable discussion to resolve all concerns? From where you sit, Mr. Franklin, are you confident that they can in the environment, the often polarized political environment we live in today?
In the state of environment that we see today, when you see a comment that says not one comma will be changed, that really opens the door for no change at all. Sit down, be quiet, and take what we give you. And I think people right now have said, I've heard enough. I think from prior to the Trayvon Martin case, many of our young folks, and me myself, I had no idea what stand your ground was. I never used that term, never thought about it. I'm not a lawyer. But the spark in interest that has come up from our young folks today, the social media aspect of how they have generated a fever for more information, how the law affects them directly, that has pushed the civil rights movement on one side to the next level?
Bottom line, yes or no, do you think we will see fundamental revisions to the law next spring?
No.
Senators and representatives, you'll be the ones sitting there. Do you think we'll come out with some fundamental improvements to the law, yes or no?
Yes, I do. I'm
Representative Kerner?
cautiously optimistic.
Yes, I do.
Senator Smith?
At least in the Florida Senate, we agree more than we disagree.
We shall see. We know, as I always say to our guests, that we can only begin to scratch the surface of an important topic, but the fact that you all are here to allow us to do that with these learned people who gave of their time and their intellect and their concern for the state of Florida means a lot, and it means a lot for you to hear. I'd like to personally thank the Forum Club for inviting me, and now turn it back over to our host.
Wow, that was truly, truly extraordinary. This is the debate that the Forum Club works for. This is what we need. We have 7 people who have different viewpoints sitting on the same stage, discussing those viewpoints in an intelligent, rational, passionate, but respectful fashion. This is what our country needs more of. I want you to congratulate all of these folks for what they did here today, because this is the type of discussion that we need in this country.